The Appellate Division First Department is now in session. Good afternoon, everyone, and welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar, so please listen carefully. People versus Dexter Murray for the appellant.
Good afternoon, Your Honor. For Dexter Murray, Adam Murphy with the Office of the Appellate Defender. 6
and 2, and
Yes.
The respondent.
Good afternoon, Your Honor. This is Melancha Chanda for the people. And Your Honor, right now I can see Justice Gish, but I could not see Your Honor right now on my screen. So I just wanted to let you know that.
Okay, well, I can hear you. I can't see you, but I can hear you. So it's 6 minutes.
I have my camera on, so I'm not sure. So I apologize for that.
Okay. The City of New York versus Travelers Property and Insurance Company for the appellant.
Amy Gross from Keenan Associates for the appellants. Good afternoon, Your Honor.
Good afternoon. 5 and 1 for the respondent.
Kate Fletcher for the City of New York. Good afternoon, Your Honor.
Good afternoon. 5 minutes. Jabuki M versus Nicole B is submitted. People versus Alexander Fuentes for the appellant.
Good afternoon, Your Honor. Alex Don of the Legal Aid Society for appellant Alexander Fuentes. And with the court's permission, could I reserve 1 minute for rebuttal? 3 and 1.
Okay, 3 and 1.
Thank you, Your Honor.
Sure. And for the respondent?
Good afternoon, Your Honor. Jennifer Westfall for the people.
Good afternoon. 3 minutes. People versus Joseph Garner.
Yes, good afternoon, Your Honor. Good afternoon, Your Honor. John Vang for Joseph Garner.
5 and 2 for the appellant, for the respondent, I'm sorry.
Good afternoon, Your Honor. Sheila O'Shea for the people.
6 minutes. MCQ Children is submitted. People versus Valerie Martinez for the appellant.
Yes, good afternoon, Your Honor. For the appellant's Legal Aid Society by Ying Yang Ma. Can I reserve 1 minute for rebuttal, please?
4 and 1. For the respondent.
Jeannie Campbell Urban for the people. Good afternoon, Your Honor.
Good afternoon. 5 minutes. Derringer versus FGG Productions for the appellant.
Hi, good afternoon, Your Honor. Lena Chen from Logan Loeb for Sony Music.
5 and 1. And for the respondent.
Anthony Mata, Your Honor.
5 and 1. Wagner versus Pegasus Capital for the appellant.
Good afternoon, Your Honor. David Rosenberg from Todd and Levy for appellant Leon Wagner.
5 and 1. I'm going to ask that anyone who's not speaking should turn off his or her mic. Thank you. For the respondent.
Good afternoon, Your Honor. This is William Mack of David Hutcher and Citron for the respondents. 5
minutes. People versus Odell Rhodes for the appellant.
Yes, Alma Gonzalez, Center for Appellate Litigation for Mr. Rhodes.
3 and 1 for the respondent.
Good afternoon, Your Honor. Rachel Bond for the people.
4 minutes. Leck versus Leck for the appellant.
Stephen Storch of Storch Byrne for the appellant.
6 and 1 for the respondent.
Good afternoon, Your Honor. Kelly Frawley, Kasowitz Benson Torres for the respondent.
5 minutes.
Thank you, Your Honor.
State Division of HR versus Austin is submitted. Lil Joe Realty versus New York State DHR, is submitted. Samuelson versus Woolman Rink is submitted. The first case for argument is People versus Dexter Murray.
Good afternoon, Your Honors. For Dexter Murray, Adam Murphy with the Office of the Appellate Defender. The best evidence of pretext is when a prosecutor's justification for striking a black panelist applies equally well to a white panelist who is permitted to serve. And that is precisely the case here. At Batson Step 2, the prosecutor claimed that she struck Mr. Robinson, a qualified black panel member, because he was unmarried and has no children and lives with roommates. According to the prosecutor, someone with those characteristics will be less likely to understand a domestic violence situation. At Batson Step 3, Mr. Murray, without any formal legal training, demonstrated that this reason was pretext by specifically pointing to two seated white jurors, Mr. Palacuccia and Ms. Guida, who shared those very characteristics. They too were unmarried, had no children, and did not live with family. Mr. Murray asked why those two seated white jurors, but not Mr. Robinson, were permitted to serve. At no point during the Batson hearing did the prosecutor answer this question or even attempt to explain her disparate treatment of such similarly situated jurors. In addition to those two similarly situated jurors, you have an additional 5 jurors who share the same characteristics that provided the basis for Mr. Robinson's removal. They were unmarried, had no children.
Counsel, this is Judge Owing, and actually, after this was all done and the jury was impaneled, the prosecution offered up an additional explanation as to why the preemptory challenge was made against Mr. Robinson. And it kind of strikes me, although the word education didn't come up, it was inescapable that that was not challenging Mr. Robinson's education, but sort of in the back doorway by saying that the other juror who was seated had more reading abilities or was able to read more, right? I mean, that kind of strikes as kind of odd, isn't it? It just didn't sound right.
I believe that's right, Justice Owing. I think first the court should be hesitant to even consider those after the hearing justifications because the hearing was closed. It was never reopened.
Well, on the contrary, those comments, if you look at them, are not helpful at all to the prosecution, right?
Yes, I agree with that, especially when you look at Mr. Palacuccia versus Mr. Robinson. They're seated right next to each other on the panel, and Mr. Robinson was gainfully employed and never indicated that he read, and Mr. Palacuccia was self-employed and never indicated that he read. And so the notion that Mr. Palacuccia was somehow more able to follow the instructions and understand the law is difficult to take seriously. Not only
yes,
because,
and let me ask you, this was a resisting arrest, violating an order of protection. This was not a heavy duty, not that it really matters, but this was not a heavy duty financial crime situation where you had to look over tax returns and all sorts of formula and securities regs and all that kind of stuff, right?
That's exactly right, Your Honor. It was a straightforward case. And, the prosecutor's reason was for striking Mr. Robinson. She said that someone with his characteristics couldn't understand a domestic violence situation where the complaining witness wasn't testifying. But yet elsewhere in the trial, if you look to page transcript 140, the prosecutor specifically says that there are no charges here where the complainant's testimony is at all relevant to the case. And so even on its face, the explanation is highly suspicious.
Counsel, did the prosecutor give an explanation for not striking Palacuccia and Guida?
At no point during the hearing did the prosecutor give an explanation to striking Mr. Palacuccia and Ms. Guida. The court at one point attempted to give an explanation for Ms. Guida and said Ms. Guida is a woman, which of course is a gender-based characteristic. And so the court and not the prosecutor actually substituted one pernicious Batson classification for another. At no point during the hearing did the prosecutor say anything about that. And with real reason to be concerned and looking directly to this court's review, after the jury was impaneled, sworn in, instructed, and sent home for the day, and only then did the prosecutor attempt to make some sort of explanation, which was really rooted in differences of perceived intelligence and morality and not supported by the record. And if you
finish your statement.
Oh, no, go ahead, Your Honor.
Even if that was what was I going to say? We can't, that the at that point it was closed. We can't consider that, can we? I mean, even if it was a basis, and we can't, can we consider that?
I think it would be difficult for you to consider that. And so what you're left with is Mr. Murray at step 3, specifically pointing to 2 similarly situated jurors who were treated disparately, and the prosecutor having no response. And what appellate courts have said in the United States Supreme Court in Miller L, and most recently in Flowers, and this court in Watson and Stevens has said is that the single most important factor in determining pretext is the disparate treatment of similarly situated jurors. And when at step 3, you have that and the hearing is closed, and the only attempt, not even by the prosecutor, but by the court to find some sort of explanation for it is to rely on a gender-based justification to replace a race-based justification, you have a clear Batson violation. It's about as clear as a Batson violation can be. And then on top of that, you have a total of 7 similarly situated white jurors who are allowed to sit, who possess the very characteristics that provided the basis for Mr. Robinson's removal. And so when you have 7 seated jurors, half of those impaneled, who share those characteristics, it is just overwhelming evidence of pretext.
Thank you.
Thank you.
Ms. Chanda?
Sure.
I saw you a minute ago. I don't know.
I know you've been coming in and out too, so I'm not sure how.
All right.
I'm
well,
not
we can
navigating
hear you
this
clearly,
very
so why don't you go ahead and begin?
Sure. Okay. Thank you, Your Honor. May it please the court, defendant's Batson claim is partially unpreserved and completely without merit. Before the trial court, he raised challenges to only 2 jurors, and the record supports the trial court's finding.
I'm confused about that. He said he said all of them. He said there were only 5 African Americans and that all were excluded save 1. So how is that not related to the entire panel?
Well, excuse me, Your Honor, the court asked him specifically which jurors are you specifically challenging, and he named.
But before that, he said the prosecutor was excluding all the blacks, and then he said the number, and then he went on to say he was specifically challenging Robinson and Israel.
Mm-hmm.
Is that not correct?
So, I think the record's a little unclear because he says something like the jury, it omitted all African Americans but 1. So it's unclear because, as we said in our brief, the purported fourth juror is never specifically identified, and it's unclear whether.
I read the transcript, and it's clear when you read it that what he's talking about, and that we're at the very least talking about the 4 who were called up, and he mentions 5, and that's all there were 5. And then he specifically talks about the 2 that he takes issue with. But how do anyway, is there a race neutral basis given here by the prosecutor? Because the court definitely turns to the prosecutor and asks that question.
Yes, Your Honor. The step 2 burden of the people was completely satisfied by by saying that she chose to strike Mr. Israel, who's not at issue right now because of his brother's conviction by the office. And with respect to Mr. Robinson, she provided a race neutral reasoning, which was that he was an older man who lived with a roommate and was childless, unmarried, and was worried that he couldn't understand or relate to the complexities of this domestic violence situation. So that is essentially.
If I could just ask a question, I don't think Batson just speaks to just making any statement that doesn't have the word race in it. I think there has to be some validity to the statement, and there can't be it can't be that it really plays on race anyway. And here, what's being stated is that the person was excluded because there was, I think he said something about higher paying jobs or something like this and reading. And the defendant directly spoke to that issue. And I have to go back to what Mr. Murphy said. Is there anywhere in the transcript where after we went, and I know I'm going from the second to the third prong, but after it went back and the defendant said, there's similarly situated white people here who weren't taken off, to suggest that that was pretext. Was there any answer to that? And if so, where in the record is that?
Well, first of all, Your Honor, I don't believe defendant met his step 3 burden because he said they were similarly situated and they were not. I mean, one was a woman and one who, again, could possibly, again, it doesn't have to be a valid, or a reason could be unfounded, as the case law says, as long as it's, a race neutral.
We understand that. I'm sorry, this is Judge Gish. I just want to get to that issue about one being a woman. That was said by the court. The prosecutor didn't offer that as a distinguishing characteristic.
Well, Your Honor, first,
and I don't understand, is the implication of that that unmarried women who live alone would be better to understand domestic violence issues than unmarried men who live alone or are with roommates? I just don't understand.
Again, Your Honor, it's not this court's role to determine whether that was a sound reason. It was a reason that was racially neutral.
I disagree with that. We don't have to take the reason at face value. It doesn't have to be. It doesn't have to be. It doesn't have to rise to the level of being a reason that we would otherwise find legally valid. But it's got to be something. It just can't be nothing, right?
Isn't that the whole idea of the court having to determine whether it's pretextual?
Well, right, Your Honor, she presented a reason that was facially neutral, and then it was his burden to show that it was pretext by showing that they were similarly situated. And he failed to do that by just saying that they were two white jurors and they lived alone and were childless. There was a more, as the record bore out, throughout the questioning, the prosecutor was really focused on finding out the employment and the employment level of the jurors. She asked,
right, the higher employment level, the better the juror. I think that's what the conclusion was.
And again, Your Honor, whether we agree with the soundness or
the soundness is exactly the whole purpose that the court that's the whole purpose of Batson, the soundness.
Well,
the soundness. You know what? I forgot at the beginning to give my rule about not speaking over a judge, but I want everybody to hear it right now. So if you would just wait till I finish my question, please. The soundness goes to the very issue of pretext. That's the role of the court, is to listen for the soundness. The soundness is what, as Justice Gish said, this doesn't have to rise to the level of maybe a challenge for cause, but it does have to satisfy soundness. That's the same thing as pretext.
Well, Your Honor, I believe that there is a distinction in that, whether it's something that this court would agree with, was it a pretext for her invidious discrimination? But she asked all of the panelists the same questions. She followed up with the ones who expressed an interest in reading, and she was interested in that, and that was pretty consistent. And I believe the Court of Appeals in Hecker, a case we cite, pointed to the fact that if a prosecutor is pretty consistent with every panelist that she questions, and she decides to focus on a higher education level or a higher, I mean, not even in this case, it was a higher employment level and an expressed interest in reading and current affairs, that is not a mask for discrimination if it's done if it's not done in a disparate manner. And in this
case, it has to be related to the case in some way. How is that relevant to an assault? This is an assault. You can't get more basic than that.
Again, Your Honor,
isn't that a factor that we're supposed to look to in trying to determine? Aren't those the kinds of things we can look to determine whether there's pretext here?
Your Honor, in both this court and the Court of Appeals has found that might be a factor. It's not a dispositive factor. And Hecker, again, I point to that case, specifically noted that that was a second-degree murder case that employment or education did not have a bearing on, but that in that case, the prosecutor was consistent in asking these questions and showed that her strategy was to find jurors that she believed had higher, in that case, higher education, in this case, higher employment, but those were valid when they were done not in a disparate manner, whether the court agreed with them or not. And that was just one factor.
A different question that we asked your adversary. After the court had made its ruling based upon the first reasoning that the prosecution had given, the prosecutor then gave another reason. Should we look to that reason at all?
I believe, yes, Your Honor, because I believe that that reasoning was merely confirmatory of what you saw throughout the record, and that in her
but it was
questioning
different. It was a different reason.
But the reasoning showed that she was focusing on the, panelists who read often, and that is shown by the record that she did plenty of follow-up inquiries, and she was concerned about that. She believed, in her opinion and in her view, that someone who read regularly would be more likely to follow instructions in the law. Whether or not that turns out to be true in the real world, that is not the issue. The issue is whether she.
But we're clear, that was an additional reason. That wasn't an explanation of the earlier reason. It was a totally different reason, was it not?
But it was a reason, Your Honor, I believe.
Before we get to your explanation of whether it was a good reason or a bad reason, it was different, right? You'll allow me that. It was different.
Sure, yeah.
Totally different. So the question is, once the record is closed, can we look to that different reason as being the basis for the prosecution's reason for exercising a preempt?
Well, first of all, I don't believe you need to even get to that reason, because what she offered before was a non-race-based reason and a facial neutral one that the defendant did not manage to rebut or show to be pretext. But to answer your question, I believe you can when it is consistent with what her actions were throughout the record and what the trial court, obviously in the best position to judge this, having viewed her responses, regular responses in following up with jurors who expressed an interest in reading and asking about their employment. These are concerns that she focused on those, and that was her general strategy. And that general strategy, once it wasn't disparate or she didn't treat any panelists differently, that was something that was non-pretextual. And obviously the trial court that was in the best position to gauge her demeanor and gauge what she was doing saw that she consistently was focused on these factors. Whether or not it's a factor that you or I would focus on, that the main question is, was it masking discrimination? And in this case, it was not, because she was focused on asking each panelist the same type of question. And she was.
Mr. Robinson asked if he read and what he read.
That was part of the questionnaire, yes, Your Honor, and he didn't respond to that, so there was no follow-up as a result. She followed up with panelists who expressed an interest in reading. She followed up and asked what type of materials they read. Did they read newspapers? What type? She was very detailed in her inquiries about that, and that showed to the court that those were things that she was focused on. And the employment of Mr. Palacuccia, he was self-employed at the moment, but he had run his own business. That was important to her. And whether or not you
the higher level jobs, you mean, was important to her?
Yes, Your Honor, yes. In that case, for Mr. Palacuccia, that was important to her, and maybe it meant for her that he showed more independence, he had more responsibility, but for whatever reason, she chose to value that. Now, was it a mask for discrimination? That's the main question here, and it wasn't, where she was consistent with her questioning, and she did not single out any juror solely because of their race.
Thank you. Are there any other questions from the panel? Okay, thank you. We're back to Mr. Murphy.
Yes, just briefly, Your Honor. The record belies the notion that the prosecutor cared about the higher level jobs and ability to read. If you look specifically at those 5 additional jurors, one was unemployed, one was not yet working, one was a video editor who had formerly been convicted of a crime. So the notion that he'd be more likely to follow the instructions in the law is difficult to countenance. And one worked for the Gap. And so I think, that we have this special advisor report that made clear that this moment demands a strong and pronounced rededication to equal justice under the law. And I think this case provides a clear opportunity to imbue those words with meaning. And unless this court has additional questions, I'll rest on my previous arguments and ask this court to reverse Mr. Murray's conviction.
Thank you. Thank you both.
Thank you.
The City of New York versus Travelers Property Casualty and, Company of America Insurance.
Good afternoon. Amy Gross from Keenan Associates for Defendant Appellant Travelers Property Casualty Company of America.
Thank you.
Good afternoon, Your Honors. The issue that we're here to discuss today on this appeal is how far an insurer's duty to defend stretches under a policy endorsement providing specifically limited coverage to its additional insured.
But the policy that you describe as limited has an endorsement that it seems there's a reasonable possibility covers vicarious liability.
Right. It would cover vicarious liability for the named insured's acts or omissions.
Bartlett,
yes.
the tree company.
Correct. Yes. Yes.
So why wouldn't they have to defend the city and the Conservancy?
Well, first of all, I don't think the Conservancy is at issue on this appeal, but to the extent that it is, I think we can consider that in tandem with the city of New York.
Right. Okay.
And if you look at the language of the policy, and if you look at how the law treats that language, there are, really kind of two main components of that endorsement that you have to look at, right? Was the harm caused by the acts, errors, or omissions of Bartlett? And caused by, in this context, has a very specific meaning. It has to be not a but-for cause, but a proximate cause. And there's no liability for the additional insured's independent acts or omissions. And that's where vicarious liability comes in. The problem...
Go ahead.
The problem with coverage in this instance is there's simply nothing in the underlying action that points to any liability or any...
This is Judge Gish. So let's go. So really your argument is, let's look at the complaint. So let's look at the complaint. If we look at the complaint, one of the things that is alleged, maybe imperfectly, but the city is a property owner here, right?
Correct.
Right, and they have a non-delegable duty to keep the property safe, correct?
Correct.
And the liability here is one of these blunderbuss liabilities. Anything that you did, clearly the policy wouldn't cover that, right?
Right.
Wouldn't cover that.
Right.
But it's also your contractors, your agents, your people who do stuff on your behalf. Isn't that enough to cover or create the possibility of vicarious liability because of what Bartlett did, who was a contractor who, at least according to the city, came in some months before the accident and pruned the tree? Isn't that enough?
Your Honor, it is not enough in this instance. And you're correct in looking at the underlying complaint, which understandably is not the only thing that we have to look at here because the city has also provided some extrinsic evidence. I think we can agree that if you are only looking at the complaint in isolation, there's no coverage. There's no mention of Bartlett. There's no description of a tree pruner.
You don't have to mention Bartlett.
The reference to... You don't have to, I think that what Judge Gish has already said and what she's about to say is that you don't have to name Bartlett if you're talking about the defendant's city and their agents. So why isn't Bartlett included in that where they have an agreement that Bartlett is a subcontractor or a contractor for them at the very least and is responsible for all of the trees? They're completely responsible for all the trees.
Your Honor, I respectfully disagree with your read of the contract. Bartlett is not responsible for all of the trees. Bartlett is responsible for performing services for specific trees at CPC's direction.
Okay, but in what you're talking about is in the complaint, it definitely indicates the agents. So that would include, if you're talking about Bartlett Tree Company, that would certainly include Bartlett as a contractor or a subcontractor. Can we agree to that?
We can agree that Bartlett was a contractor or a subcontractor. The issue I take with the broad brush that we're using here is that if you read the complaint, as many of these personal injury complaints are drafted, it talks about contractors, subcontractors. It has vague allegations of liability based on ownership, and that may well be. But if you
this is Judge Owen. I don't want to cut you off, but to answer your point about looking at the complaint, not only is the city named as a defendant, but CPC is named as a defendant. Correct?
Correct.
So CPC is also an additional insured under the Bartlett policy. Correct?
If there is coverage for the city, I would think potentially there would be for CPC. I will tell you, CPC has not sued us for coverage.
I'm not, well, that may be down the road, but I'm just saying that CPC and the city under this insurance policy are additional insureds, correct?
They are potentially additional insureds, right?
Okay,
The agreement
okay.
between Traveler or between Bartlett and CPC. Yes.
So your argument is at this point, your position is that the city, because of the last phrase of this the last phase of this policy provision we're looking at, that the city is liable, therefore they're not entitled to an additional insured status, correct? They're not entitled to coverage.
Not precisely. The city is liable for its independent acts or omissions to the extent that the city is making an argument that its liability is vicarious as to Bartlett. That connection hasn't been made in the complaint or the underlying facts.
Let's forget about Bartlett for a second, because CPC could be doing something too, right? I mean, what if CPC at the conclusion of this trial would be against the city and CPC? CPC is found 100% liable. Does the city get defense coverage costs from you then?
No, because the only acts or omissions, the additional insured coverage is not triggered unless the harm is based on the named insured's acts or omissions, which is Bartlett, not the CPC. To the extent that the CPC is insured, they're an additional insured.
But even on your argument, there is a reasonable possibility here that Bartlett is responsible. In their contract, they are responsible for the trees. And so that, I think you're reading this much too narrowly. This is your duty to defend. And in this instance, it's a reasonable possibility. Certainly there's that with regard to Bartlett and its responsibility, especially since, as I think Justice Gist was pointing out, I think it's 7 months prior that they, 7 or 9, whatever it is, that they treated the trees. But in the contract, the city asks them to take care of the trees. No one else has touched the trees except Bartlett. So why doesn't that create a reasonable possibility?
With respect, Your Honor, again, the contract specifically limits Bartlett's ability to work on these trees at the direction of the CPC. If the CPC tells them to go and prune a tree one day, they go and prune that tree, but they don't have the obligation to or the right to inspect and make decisions about which trees to prune.
Let me stop you because I don't really understand what difference does that make in terms of what we're talking about here. So see, there's a possibility in this record that the only liability that the city has is vicarious, all right? Now that you say, and I understand under the contract, it has to be vicarious liability on account of Bartlett's negligence, right? Okay, and Bartlett may not be named here, but they do name generally, you are responsible as the property owner, non-delegable, for your agents, et cetera, et cetera. So Bartlett is really not out of the question here, since there seems to be some indication that Bartlett was directed to do the work by CPC and went and did it. And the question is, were they negligent? And wouldn't that trigger the responsibility to cover the city as an additional insured?
With respect, Your Honor, two things I want to point out with this. I know, just want to be clear about that. Two things that I want to discuss.
Clear.
One is the underlying complaint. I know, I respect you very much as well, Your Honor. I respect everyone. The two issues I want to talk about, one with respect to the underlying complaint, one with respect to the contract. With respect to the underlying complaint, Your Honor is absolutely correct. The underlying complaint mentions liability, mentions that the city owns the premises, mentions contractors, agents, et cetera, et cetera. But if you rely simply on the fact that there is an unspecified reference to agents, contractors, et cetera, that could theoretically implicate any contractor or agent, regardless of any allegations against them, regardless of any any theories of liability that have been raised in the case tying these individuals or these companies to the case. So I don't think you can rely simply upon a reference to agents or contractors in order to come up with a vicarious liability against a specific named insured. Now,
okay, let's move on to, we've gone over quite some time, so let's move on to Ms. Fletcher, I believe. And you have rebuttal, Ms. Gross.
Good afternoon. May it please the court, Kate Fletcher for the City of New York. I would agree with your honors that here the extrinsic evidence together.
You know, counsel, I got a quick question to ask you. You know, this whole thing could be resolved if somebody just third parties Bartlett. Is that? I mean, that seems like, unless I'm missing something, this whole argument is swirling around the fact that Bartlett is not a named defendant, and that, you know, at this point the city or CPC can be directly held liable. And we're saying that the contract or the complaint seems to include Bartlett by way of agents and subcontractors and so forth. So just make it easy, just third party in Bartlett, and then this whole case goes away, I would think, at that point.
I understand what you're saying, Your Honor.
But probably right after this argument, there's going to be a third party complaint.
I understand what you're saying. I do believe, however, that the duty to defend exists here regardless of whether Bartlett is named. I think that the case law is quite clear on that. The decision in Wausau establishes that quite plainly. And I would say that the Travelers has not created any reason to suggest that Bartlett absolutely cannot be responsible for Fruman's injuries. And accordingly, there's a reasonable possibility, and Travelers has a duty to defend. And I would just, you know, again,
I think the argument's going to be as discovery goes forward here. It's clear that, to me, based on this record here, the city hired CPC to do the work, and then CPC hired Bartlett to do all the work. Okay, so in terms of the non-delegable duty, that at this point, if we were to go to trial on this case with just the city and CPC as the named defendants, I would suspect that the liability that the city is going to be hit with would be vicarious.
I think that is correct, Your Honor. And I think that directly implicates the contract here. And because this contract for insurance was specifically covering when the city is held vicariously liable for Bartlett's actions. And because Bartlett was the one who worked on the tree, and because it is entirely reasonable that those actions or omissions could have led to Fruman's injuries.
I'm just making it simpler, much simpler than that. It doesn't matter in terms of the city's position here. It doesn't matter because the city's going to come forward with evidence, unless the record's going to prove otherwise, that we didn't do anything. We hired people to take care of everything. So it doesn't matter who did the work. The liability against the city would be vicarious.
Right, but they are entitled to a defense, Your Honor, and
I'm not arguing that. You got to understand when you're on the side that where I'm trying to help you here.
Yes, Your Honor. Forgive me. I hear what you're saying. And
I think that's called a softball question.
Yeah.
In any case. Do you have anything
Your Honor?
further,
I don't have anything further, Your Honors.
Okay,
I appreciate your time. We rest on our brief.
Thank you. Back to you, Ms. Gross.
Thank you, Your Honor. Just one additional point I'd like to make with respect to Bartlett's duties under its contract with the CPC. Again, it didn't have discretion to choose which trees it pruned. It didn't have the authority or the discretion to conduct inspections and recommend trees to be pruned. Its involvement with the subject tree began and ended in December of 2015, 7 months before the accident. To the extent
So
the city
counsel, this is Judge Mendez. Are you saying that once Bartlett pruned the tree, if there was anything wrong with whatever Bartlett did, Bartlett could not have said, well, you know, I have to fix what I failed to do when I pruned the tree originally? Is that what you're trying to say? They have to seek permission from the city before they do that?
I mean, I don't know how it specifically functioned under the contract. I would think they would raise that. If they went and discovered a mistake, I don't know if it would function differently. I do know there was not an ongoing obligation to inspect that work once it was done. So to the extent that there may have been an issue that arose after, or there may have been a need to inspect and discover a problem, that is an issue for the CPC in the city. That would not be vicarious liability for something that Bartlett failed to do if an inspection should have been done and something should have been caught and it wasn't, since that was never assigned to Bartlett. And in that respect, it really highlights.
Well, let me say, I don't know, but that's not really the issue in front of us. I mean, there's still we're talking about possibilities. There's a possibility, as Justice Mendez said, that the pruning itself was negligently done, in which case that would make Bartlett responsible, or in part responsible, a proximate cause. We don't know that yet. We're not really at that point.
Right. We don't know that, Your Honor. We do know that this case has been on file for a number of years. That theory has never been articulated by the city. It hasn't been raised in a claim by the plaintiff against Bartlett.
Because as Justice Oing said, nobody put a third-party complaint in. Yeah.
Well, but that's not irrelevant. The duty to defend is very broad. Yeah. It's not unlimited. It can't be based on speculation or conjecture about what somebody might one day claim. And the fact of the matter is, nobody has asserted a claim against Bartlett at this point. The city has come up with some speculation about, what may be the basis of a claim, what may be the basis of liability, but that alone doesn't get you over the line.
Counsel, I have a funny feeling before the ink is dry today, Bartlett's going to get served with a third-party complaint.
In any case, we thank you. We understand your argument. Thank you. Thank you both.
Thank you, Your Honors.
Thank you, Your Honors.
Yes. People versus Alexander Fuentes.
May it please the court. Alex Don of the Legal Aid Society on behalf of appellant Alexander Fuentes.
Yes.
Your Honors, I respectfully request that the court reduce Mr. Fuentes' term of probation to the 3-year minimum. Because even at the time of sentencing in mid-October of 2017, Mr. Fuentes had already demonstrated that his life was completely back on track. A graduate
How much more time does Mr. Fuentes have on probation? And what has he done over this period?
Your Honor, he was 5 years of probation was imposed in October of 2017. So that takes us to October 2022 is the end of the probation.
So a year and a half, maybe a year and 3 months, something like that.
Roughly speaking, Your Honor. And how he's doing today, in response to your question, no new arrests, no new negative law enforcement contacts.
And my question is, what has he been doing?
I'm sorry, Your Honor. He shortly after the incident in this case, he began his own cleaning business. Which has been thriving and had been thriving for 2 years at the time of sentencing in this case, continues to thrive, has now been operational, and he's been supporting himself entirely through that business.
And so how has the probation thwarted his efforts to run his life? I mean, you just talked about the cleaning business that's doing really well, that's thriving. So why should we be reducing the probation here?
Your Honor, probation should be reduced, not necessarily because the fact of probation has thwarted Mr. Fuentes' efforts to improve his life. He's had remarkable success and dedication to getting himself back on track, but because the principles of sentencing require that we impose ultimately no more of a penalty than is necessary for society to be safe and for the defendant to get his life back on track. And in this case, we submit that those goals have been met here. He's been at liberty for 6 years at this point with no negative law enforcement contacts. He's started his own business, complying with probation 100%. He's on the board of a nonprofit organization dedicated to helping displaced LGBT youth. In short, he's really doing everything he needs to do to be a productive, law-abiding member of society. And while I can't specifically, because of his success, point to a way in which probation may be thwarting him, I can argue, Your Honor, that no more probationary supervision is necessary in this case.
I have
I'd also
questions, counsel. 2 questions. Has he paid the restitution?
Yes, Your Honor, entirely.
And how often does he report to probation now?
Your Honor, I believe because of initially he saw probation weekly. Then as he was succeeding in that way, it was reduced to monthly and then quarterly. When COVID began, he began reporting pursuant to probation requirements. He'd been reporting monthly over the phone is what I understand of how he's been doing. But throughout, he's been doing everything that he's been expected to do. The business that he started, which is called Cleaner, spelled with a K with an apostrophe instead of the E at the end, which is in the brief, has been thriving. He's 35 years old today. He lives alone. He's continues to be dedicated to maintaining the positive direction that his life has taken. I just add that there's no appeal waiver in this case that would prevent this court from in the interest of justice, reducing his probationary term to the minimum.
Any questions from anyone? Okay, thank you.
Thank you, Your Honor.
Ms. Westphal, I think.
Good afternoon, and may it please the court, Jennifer Westphal for the people. After stealing thousands of dollars from a nonprofit charity, defendant bargained for and received a sentence in which he avoided prison entirely. His restitution was.
It was $4,180. Sometimes when we say thousands of dollars, we start thinking about 20,000, 30,000, 40,000. We see large numbers here. So 4,180, and he's completely paid it back.
Yes, and that was the condition for him to get probation rather than an actual prison sentence.
This was his first arrest, was it not?
In New York, yes. I believe he had prior contacts in Pennsylvania, a DWI, and I think he provided false documents to law enforcement.
During the DWI?
I believe so, yes.
Yeah, so that was really one. Okay.
Yes. It's our position simply that his sentence was fair and it shouldn't be disturbed.
And by the way, how old was he with the DWI? Do you know? What year did you say?
Honestly, Your Honor, I don't know his exact age. I believe he was younger.
Counsel, this is Judge Owings. So what do we hope to accomplish by keeping him on probation for another year and a few months?
It sounds like the period of probation has been providing him with stability for rehabilitation and as a means of aiding him in becoming a productive and reliable member of society. However, it does sound like he is also in a new position of trust with another nonprofit. That extra year and a half could provide him the continued means of maintaining his stability and also maintaining the trust of that nonprofit. Unless there are any other questions, I respectfully ask that you affirm.
Thank you. Back to you, Mr. Robinson, I believe. I'm sorry.
Alex Don, Your Honor,
Don,
I know I have only 1 minute. Very briefly, I believe he was 22 years old at the time of the providing false records in connection with the Pennsylvania case, which was a misdemeanor, which occurred in 2007.
Do you know about him being in a position of trust with a new nonprofit? What's that?
Your Honor, I had mentioned in my opening statements that he serves on the board of a nonprofit organization called Out My Closet, that is a nonprofit dedicated to helping displaced and under-resourced LGBT youth. I have no information that he has.
Is probation, I imagine that probation is aware of that. Are they aware of that and aware of his role there?
Your Honor, I don't know the answer to that question, and I also don't know to what degree he's involved with any funds or anything like that. I believe it's something he's doing for the goodness of his heart.
Sign a waiver. There's no waiver signed here.
There is no appeal waiver in this case, Your Honor. And I was beginning to mention, I'll just close with this, that the underlying facts behind the underlying incident are that the regrettable actions he took were taken in order to obtain money to help his mother escape a violent domestic situation. Not a justification, but a background explanation that certainly doesn't call for anything more than the minimum probationary term here.
Okay, thank you. Thank you both. People versus Joseph Garner.
Yes, good afternoon, Your Honors, and may it please the court, John Vang for Joseph Garner. Your Honors, in this case, the court abused its discretion in denying Mr. Garner an adjournment to prepare his case. And the court denied that adjournment, reasoning that it would treat him like an attorney. But the truth of the matter is that it wasn't here. In this case, the court
I can see that others may well have done differently in this case and granted an adjournment. However, I think just the day before or something, the attorney who was withdrawing from the case made a statement to the court that he had produced everything to the defendant, and in fact that the defendant had had all the materials, relevant materials, for 7 months or some number of months. So did this prejudice or harm the defendant at all that the judge did not give the adjournment?
Well, I don't think it's exactly accurate that Mr. Garner had all of the materials for 8 months. Mr. Garner made clear actually the next day during a colloquy with the court that, that's what the defense attorney said, but he gave me the paperwork from the other case. He didn't give me the paperwork in this case. And you can verify that by the record that he makes on the second day of the hearing, when it turned out that what happened was defense counsel had given the paperwork to standby counsel. And at that point, Mr. Garner made clear, look, I finally have all the paperwork in this case, which counsel had given to standby counsel. Can I please have an adjournment at that point? And I'll point out at that point that the court didn't discredit that factual representation. The court still denied the adjournment, reasoning that the witnesses were present. So I would also point out that it's really not the basis for the court's ruling that he had all the paperwork. I mean, that was something that the court said, but really the court's basis for denying the adjournment here was that it was treating him as an attorney, and that the witnesses were here. And both of those grounds, as the record shows, didn't justify denying the adjournment. I also point out,
how many attorneys did Mr. Garner have?
He had only had one.
Mr. Delbaum was the only attorney he had?
Yes, Mr. Delbaum was the only attorney he had, and there was a period about of nearly a year when there was a significant breakdown in the relationship between the two. I mean, Mr. Delbaum wasn't bringing Mr. Garner up for court for nearly a year. There was no communication about the case. That was exactly what prompted Mr. Garner to seek self-representation. I think there's reasons to question the accuracy of Mr. Delbaum's representations that, he in fact gave Mr. Garner all the paperwork, since he really wasn't seeing Mr. Garner during the year leading up to trial, at which point Mr. Garner decided, I'm going to represent myself. No one can represent my interests.
Well, Mr. Delbaum said that the reason why he had not seen Mr. Garner is because he refused to come to court.
Well,
he refused to come to court, and he refused to meet with Mr. Delbaum.
I don't think that was consistently the reason.
That was, as an officer of the court, that's the representation he made to the court.
Right, and that's fine, and that's true, and that's a representation that he made. But in terms specifically of the representation that he made about the paperwork in this case, the record bears out that Mr. Garner did not, in fact, have the paperwork in this case, that Mr. Delbaum had, in fact, given it to standby counsel, Mr. Grosstern. And the second day of the hearing, when Mr. Garner, in fact, spoke to standby counsel, he explained, look, I finally have all the paperwork. And there's reasons to credit that. I mean, if he was just really trying to obstruct the proceedings and really just trying to be a difficult litigant, he wouldn't have said that. He wouldn't have said, look, I have all the paperwork finally. After he had all the paperwork at that point, he completely cooperated with the proceedings. He cooperated with the court, and then he never asked again for an adjournment to prepare for his case. So I think that shows that this representation was in fact credible. But again, I'll point out that, really the issue here was that the court denied the adjournment because it said that it was treating him, as an attorney and that the witnesses were already present. But again, those grounds were not legitimate grounds because, again, the court even granted standby counsel an adjournment during the brief period of time that it, ordered an adjournment. When it terminated Mr. Garner's representation, the court even granted Mr. Grosstern an adjournment. So,
thank you.
Wasn't that sufficient for Mr. Gardner to prepare? Once he had all the paperwork,
he did not have all the paperwork at that point. No, that's the point. Is that the second day of the hearing, he did not have he had finally had all the paperwork, and at that point, he asked the court for an adjournment to prepare. The court still said no. The witnesses are here, and our argument is that the witnesses being present, particularly in a case where they're local, doesn't trump his constitutional right to prepare a defense in this case.
Thank you, Ms. O'Shea.
May it please the court, my name is Sheila O'Shea and I represent the respondent on this appeal. Contrary to what my adversary has argued, I believe that the record does in fact support the court's finding that the defendant did in fact have the paperwork he needed prior to the suppression hearing and thus was not entitled to the adjournment he requested. Several things. On the May 22nd, 2017 court appearance, Mr. Delbaum indicated that he had sent a letter to the defendant indicating that he had sent defendant, I'm quoting, all the material in the case. He also said, as my adversary has not responded to in his papers, that he had given all the Rosario material to defendant in October 2016. That was some 6 months before the date of the hearing. As I've argued in my brief, the Rosario material was not voluminous. It was about 19 items and 173 pages. And as has been pointed out, Mr. Delbaum was May 23rd. The following day, defendant tells the court that he hadn't seen the relevant paperwork, but Judge Jackson pointed out to him prior counsel had provided all of that to him, which is consistent with the record from May 22nd. The judge also pointed out that the defendant had made a representation that defendant had received absolutely everything on this case and the other case over the past couple of months and had it in Rikers with him. And now, while it's not clear from the record when that representation was made, again, that's the judge's recollection of a representation that the defendant had made and certainly provides record support for her finding. And with respect to the basis for her reasoning, I think that I think the main reason, or certainly a large component of her reasoning, was that she believed the defendant did have the paperwork, because on May 24th, defendant comes into court and said he had just received the paperwork and he requested an adjournment, and the judge said to him, you had all the paperwork. So I think it's a fair inference that the basis, or one basis, for denying the adjournment was because defendant did in fact have the paperwork. I can address other arguments if the court would like, as to preservation and other issues. Would the court like me to address anything else, or?
Any further questions? No, thank you.
Thank you, Your Honor.
I'd like to clarify actually what my adversary it's a misrepresentation that the judge said that you had everything with him at Rikers. That's not actually what the judge said. The judge thought that he had received absolutely everything on this case and the other case, not that he had it with him at Rikers. And that was actually a misunderstanding because the judge had actually gotten that representation from Delbaum. That is a representation that Delbaum made the court. Now, while it's true that the court was entitled to rely on the Delbaum's representations, the fact of the matter is that, first of all, he had two cases in this case, and Mr. Garner continued to make it clear in this case that, he had given me the paperwork from the other case, not the paperwork in this case. And again, that's something that's really important to remember, because on May 24th, again, when he appears in court and has finally spoken to standby counsel, who Delbaum had given the paperwork to, at that point he represents, look, I finally have all the paperwork at this point, but I still need an adjournment. And then the court denies it. And again, he no longer asks for an adjournment thereafter. And so I think to the extent that my adversary is suggesting that Mr. Garner is somehow misrepresenting having a complete set of paperwork, it's belied by the May 24th record that, again, my adversary doesn't respond to. So again, if he was just trying to obstruct the proceedings, he would have continued to do that throughout the proceedings, but he didn't at that point. He was respectful to the court, and then thereafter he came and tried the case without making that objection any further. So I think what happened here is that Dalbaum, was obviously mistaken. There was another case. He had given the paperwork from the other case to Mr. Garner, but Mr. Garner did not, in fact, have all the paperwork in this case, and that prevented him from making and preparing for, to make suppression arguments. And there were a number of suppression arguments that he could have made that could have very well carried the day. So, this is a pro se defendant. Denying him an opportunity to prepare a case is, really prejudicial. This is something that courts routinely offer, to attorneys when they've been newly assigned to a case. The only basis for the court's ruling here was that, it was treating him like an attorney and, that the, witnesses were present. None of these justified denying the adjournment. So for these reasons, we would ask that the court reverse.
Thank you. Thank you both. People versus Valerie Martinez.
Yes, good afternoon, Your Honors. For the appellate, Valerie Martinez, the Legal Aid Society by Ying Ying Ma. Ms. Martinez is a survivor of severe childhood trauma and sex trafficking, and these experiences mitigate both the underlying offense here and her inability to complete the therapeutic programming that was offered to her as an alternative to prison during her case. And for these actions, she was duly punished with 3.5 years in prison, her first and only experience of incarceration, and she has now been on post-release supervision since May 2018. That's over 3 years ago. So the remaining 2 years of post-release supervision until May 2023 on her 5-year term, which is the legal maximum, is clearly excessive, and we respectfully ask for a modest reduction to the minimum of 2.5 years. The maximum term here is unnecessary and unjust given the circumstances of her case. As laid out in our brief, there's incredibly compelling—
This is Judge Owing. Did she complete her 3.5-year sentence?
She completed it, yes.
Completed. So now we're looking at you're seeking a reduction of the PRS from 5 years to 2.5. That's what you're looking for, correct?
Yes. I don't believe that she should have gotten the maximum 5-year term.
So my question about the firearm that was recovered, it wasn't recovered on her person?
No, it was not on her person.
In fact, it was on a rooftop, right? It was on a rooftop?
Yes, it was on a rooftop, and as the court below, and as this court knows, she is a survivor of sex trafficking, and her offense in this case was related to her being trafficked. It was during a job with a client, and as we've laid out, that experience of trafficking is highly mitigating in this case. And furthermore, but for the trauma coerced bond that her trafficker maintained with her, which led her to leave the court-mandated programming that she was in and return to her trafficker, she never would have been sentenced to prison time. She was being given—
just to clarify, sorry to interrupt. When was she released? How long has she been on probation? That's what I'm asking. I know it will be, if it's 5 years, until May 2023. But when did she begin her probationary term?
Yes, she was released May of 2018. So that was over 3 years ago at this point.
And what is she doing? If you could remind me.
Yes, well, she has had no new arrests or technical violations, and she's just finished her first semester at the Borough of Manhattan Community College, where she's studying psychology. She also works currently as a home health aide. Prior to the pandemic, she was employed in a thrift store that's connected to the programming that she was doing at a program for formerly incarcerated women called Our Children. And she had significant leadership roles there. She co-facilitated a mentorship group. She currently lives with her partner, and she has currently completed all of parole's required programming. So she reports every 4 months to parole at this point. But I do want to know—
children? Do they live with her, or?
No, that is one of the things that I think continues to be a burden for her in terms of being on continued supervision, is that her children live out of state. And so she has to apply for advance permission to see them to parole. And in addition, as we described in our brief, I think it is a continued safety concern for a survivor of trafficking to have to report on a regular basis to a known location. She's also limited in the employment that she can get while she's on parole in terms of having to get permission for out-of-state jobs, like jobs in New Jersey. She's also still subject to random home visits and drug tests, despite 3 years of being a model parolee. And of course,
you said she reports every 4 months. So, I mean, how would anyone know to track her every 4 months? They'd have to be there every day. So in terms of harm to her, I mean, is that high on the list?
Well, I mean, I think it's a possibility. I think we don't always foresee the lengths to which abusers go to stalk their victims. And I just point that out to say that, you know, that has been a concern all along, and it might be somewhat less of a concern because she reports so infrequently now, but it is, I think, another reason why there can be not only a failure to, there can be just like continued parole can be ineffective, but can also be harmful.
Counsel, I have a question. The waiver here that was entered into by your client, it was a court proposed waiver, right? I mean, the prosecutors never put forth a waiver. Is that what happened here?
Yes, this was the court offered Ms. Martinez a plea to a sentence that it believed was appropriate, which was the 3.5 years in prison and 5 years post-release. The district attorney wanted even more time than that in prison, but the court decided to undercut that, and then the court itself proposed the waiver. So we submit that it was not a bargain for a component of the plea in this case.
Thank you.
Thank you. Ms. Campbell-Urban?
Yes, Jeannie Campbell-Urban for the people. Good afternoon. If you would allow, I'm sorry, I'm a little bit off screen. Let me try to center myself. I'd like to begin by responding to counsel's remarks about the waiver of appeal just briefly. I disagree with the argument that it was Justice Jackson's idea to impose the waiver of appeal. In fact, at the defendant's Supreme Court arraignment over a year before she pled guilty, the people, when they gave their sentencing offer at that time, said that they would require a waiver of appeal. At the plea colloquy, it was Justice Jackson who asked the people whether they were requiring a waiver of appeal, and the people responded affirmatively. Also, if you look at the terms of the plea agreement, it's clear that the people were the ones requiring the waiver of appeal because the people permitted the defendant to plead to just one count of the 5-count indictment.
Is there a written waiver?
I'm sorry?
Counsel, is there a written waiver?
Yes, there was a written waiver of appeal that the defendant executed after her attorney reviewed it with her and explained it to her. The defendant is on the record at the plea colloquy telling the court that her lawyer had explained the contents of the written waiver to her. So, you know, the Court of Appeals case in Thomas talks about this specifically, the counsel's participation in ensuring that her client understands the terms of the waiver of appeal is crucial. And there's a great record here that demonstrates that defense counsel did her job and explained to the defendant that she was waiving her right to appeal, including specifically her right to make an excessive sentence claim. So I want to turn to the merits of the excessive sentence claim, but I'll just say that the record is very clear that the defendant voluntarily waived her right to even bring this claim before your honors. With respect to the defendant's excessive sentence claim, the people are not disputing at all that the defendant was a victim of sex trafficking. They were well aware of that below, as was Justice Jackson. And that's why Justice Jackson gave the defendant the opportunity over the people's objection to get out of jail and go to an out-of-state program tailored to sex trafficking victims. And just 6 weeks after the defendant got the program that she begged the court to give her, she absconded. She was allowed to leave the program unchaperoned for the first time and left 2 days later, I think. That suggests that the defendant, even despite her own best intentions, desperately needed extensive supervision. I mean, she specifically told the court that she needed supervision and support services.
Well, she got more supervision. She got incarceration, and she got incarceration for 3.5 years. Wasn't that supervision of a sort as well? And now she's been for 3 years. So she was, I think the question is, how long was she away from the pimping or the whatever that was going on that she was subject to? And as far as I can see, it's 3.5 years plus 3 years of PRS so far. seems like that's 6 years. So she got that and more. So doesn't that suggest that that's a significant amount of time, particularly that she seems to have been doing everything she needs to do while on PRS? I mean, this is not the situation that you speak of 6 years ago, where she was in a program for just 6 weeks, as you said, and then absconded. This is 6 years of treatment, essentially.
Well, I bring up the defendant's own request for supportive services and supervision, Your Honor, because they were asking for that as an alternative to jail. So I don't even think the defense would necessarily agree with you that the prison sentence was the kind of supervision they wanted. PRS, on the other hand,
prison is never the kind of supervision that someone wants, but she was away from those people who would have been subjecting her to selling herself. In that sense, she was, it's not supervision of the sort that anyone would want, obviously, but she was removed from that which was harming her.
Yes, she was made to serve the statutory minimum of 3.5 years incarceration for her crime of threatening one of her prostitution clients with a loaded firearm.
But that's not the issue. That's not the issue. You were speaking to the fact that she absconded after 6 weeks, and she's a much different person today than she was then for various different factors. That's what you were speaking to. That's what I'm speaking to.
I totally agree that her time in prison has helped her get away from the lifestyle that she was living at the time of her open case. I don't think that her time in prison means that her 5-year PRS term, which was a term that she agreed to serve when she pled guilty, needs to be reduced. I mean, first I have to say that all of the information that counsel just provided to the court about the defendant's current volunteer activities, job, and education is information that I was never provided before. You all just heard it. So I am finding myself in a little bit difficult of this position trying to respond to new information that was not in the briefs and I have never heard of before. But I would say that the fact that the defendant is doing well on post-release supervision now doesn't mean necessarily that her post-release supervision should be truncated. Who's to say that her post-release supervision isn't giving her the structure to succeed in all of the ways that counsel just enumerated for the court? If she's violation-free, arrest-free, has gone to college and has a job, then there's really no merit to the assertions in the brief that post-release supervision is holding the defendant back from becoming more educated and gainfully employed. So for those reasons and the reasons in our brief, we would ask that you affirm.
Thank you. We're back to you, Ms. Ma.
Yes, Your Honors, I do want to respond to the fact that the trial court may have considered some of this information below, but clearly Ms. Martinez's behavior in leaving the program was disappointing to the court, to say the least, and impacted the court's sentencing decision. And this court now has the benefit of time and distance to more fully contextualize the reason that she left, the trauma bond that she had with her trafficker that she has now broken, and to consider that she has successfully reintegrated into society. And for those reasons, we ask that you reduce her PRS to the minimum of 2.5 years.
Thank you. Thank you both.
Thank you.
Derringer versus FGG Productions.
Hi, good afternoon, Your Honor. May it please the court, this is Lena Chen from Loeb & Loeb for Sony Music. Sony has been selling these records for decades without objection. The trial judge recognized Sony's right to do so.
That's unfortunate because they must have known that they were selling those records without objection, without payment, without anything else for these recording artists who had been exploited since 1965.
Yeah, and well, the trial judge erroneously took that right away by ruling that while Sony can sell these records, it cannot identify the plaintiffs as the performers on those records. And Sony has the absolute right to do this, not only under the First Amendment, but also under the Florida and Indiana's publicity statutes, and also because, as Your Honor mentioned, these claims are entirely time barred. Now, for their part, the plaintiffs are now seeking to prevent Sony from exploiting these recordings, and therefore their claims are subject to preemption under the Copyright Act. The plaintiffs cannot dodge this preemption, even if they claim and even if they frame it as an ownership question, because that is still a claim to be decided under the copyright law under the Music Modernization Act. So on to the preemption question. These claims are preempted because plaintiffs have admitted multiple times and all throughout their briefs that they're seeking to control the exploitation of these sound recordings by asserting state law claims. Their sole argument in opposition is that preemption doesn't apply because Sony is not the owner of the sound recordings and because the sound recordings were not brought within the scope of the Copyright Act. They're wrong. Sony does own the sound recordings, but even so, preemption doesn't turn on ownership. The analysis for federal copyright preemption is over the scope of the rights asserted. So the analysis is only based on the question is, are the rights seeking to be protected under the state laws equivalent or substantially similar to those rights exclusively governed by the Copyright Act? And if they are equivalent or substantially similar, then it's preempted. And these plaintiffs have admitted that they are equivalent because they admit they're seeking to control the exploitation of the sound recordings. So the two preemption paths are explicit preemption and implicit preemption. And Section 1401 of the Copyright Act provides the implicit preemption because it provides plaintiffs with the right to seek remedies for infringement of these pre-1972 sound recordings. The Section 1401 was enacted by the Music Modernization Act, and it went into effect October 18th, 2018. Plaintiff's complaint was filed November 2018. So at the time that they filed their complaint, all of these claims were subject to the Copyright Act. All of these claims are so implicitly preempted. And there's also an explicit preemption under the Copyright Act, that's Section 301. Sony doesn't deny that 301 has a temporal limit, and so we only argue that 301C preempts the post-October 2018 alleged infringements. Turning to the First Amendment defense, these claims are also subject to dismissal because they improperly restrain Sony's speech under the First Amendment. The test and the analysis that this court must undertake is this balancing test that was set out in Zucchini, the Supreme Court case on First Amendment rights. And so this court must weigh the First Amendment rights of Sony against those protected by the right of publicity asserted by the plaintiffs. And when you engage in this analysis, it favors Sony. Sony's speech here is incidental to expressive works, this music sound recordings, and they're accurate. They accurately and correctly identify the performers on the recordings. They provide factual information only. The speech is truthful. It's directly connected to the content. It merely identifies who these people are who performed on the recordings. And so Sony has a strong First Amendment interest in being able to correctly identify the performers of the sound recordings that it distributes. And so turning to the right of publicity, the plaintiffs have a very low, if any, interest in their right of publicity. There's little to none implicated here with this use because there's no false endorsement. You know, this is not a case where Sony is selling their images, their posters. The value in the works are not the image and the likeness themselves. And Sony is also not implying false endorsement. We're not selling unrelated works and then slapping the plaintiff's name or likenesses on it to imply some kind of endorsement. Like if I'm selling records and slap Kim Kardashian's face on it because it'll attract people because her image and her likeness has value. This is not the case here because we're just identifying who's actually performing on the sound recordings. And finally, these claims are all time barred and they otherwise fail to state a cause of action against Sony Music. The plaintiffs have incorporated 5 specific uses that they allege were by Sony in the time period, and all except one are not actually directly attributable to Sony. There's one product, which is this Best of the McCoy CD. It was released in 1995, and that's the only act by Sony that is alleged in the complaint, is this release of the CD in 95. So that's time barred. None of the other uses are attributable. There are Amazon web pages that are not attributable to Sony.
So let me stop. stop you there and just ask a question. The allegation in the complaint is that Sony licensed this these products to Amazon and Spotify, who then use the likeness. Is that sufficient, or is that insufficient to otherwise bring them with the rubric of the other state statutes?
There's no allegation in the complaint that Sony licensed any of these.
Well, they say they got royalties from them. Let me take it back. I'll be more accurate, right?
Yes.
They got royalties.
The only allegation that is relevant to royalties is the allegation that Sony receives royalties from the YouTube video. And so there are several reasons why this YouTube allegation is not relevant. The first of which is that it is related to a Derringer solo recording. So that's not even one of the sound recordings.
My goodness.
Would everyone speaking turn off the mic? Justice, please. Try to keep their microphone.
Thank you.
Yeah, I think that might have been for some reason your yours. Okay, if you just wrap up, thanks.
So the sound recording isn't even at issue here. It's a solo recording by Derringer, a re-recording. It's not at issue. It's not one of the McCoy's recordings that this group actually recorded back in 1965. The other reason is that Sony owns the masters. The fact that it receives royalties has no bearing on the images because it receives royalties for the public performance of the sound recording. It does not receive any license or royalties for this photo that is attached to the video.
Okay, thank you. If you're trying to ask a question, Justice Gish, you're muted. Did you want to ask a question? I saw your mouth moving. Okay, fine.
Well, I just said I understood her argument.
Yeah, I was right. Good. Thank you. We're on to you, Mr. Mota.
Thank you, Your Honor. May it please the court, my name is Anthony Mata, and I represent the respondent cross appellants in this matter. And I think I'll dive right into the hive's nest and start my argument with the court's dismissal of the fourth and fifth causes of action for lapse of the statute of limitations. Plaintiffs contend that defendants are equitably estopped from claiming the statute of limitations. And in order to understand the reason, you have to look at the circumstances. We have three individuals, Mr. Derringer, 17, Mr. Zeringer, 15, Mr. Brandon, 19, when they recorded these songs. They were represented by their parents, who were not familiar with entertainment or music law. Immediately after they recorded the song, which became a hit, Hang On Sloopy, they were asked to sign off on a recording agreement. And this is normal in the industry.
Counsel, notwithstanding that, and I appreciate all of that, I think there are many people who were in that position at that time. The question is, how long have they been aware of this, and why did they wait till 2018, I think, or whatever year it was, to bring an action? This was in 1965. Certainly, there are decades.
We have been unaware that there was no agreement transferring rights until 2019. And if you look at my complaint, I didn't know whether there was agreement. I assumed there was because it's the norm in the industry. I mean, who releases a sound recording without a recording agreement? We only, and for that reason, I phrased.
But they never had possession of it. They never had possession of an agreement all this time. Did that not?
We still don't have possession of it.
I understand. I'm saying in terms of raising questions here, They knew they didn't have an agreement. They knew they didn't have possession of an agreement. They had never seen an agreement.
Yes, that is correct, Your Honor, but a representation was made to them by an individual who was represented to be an attorney that they were signing off on a recording agreement. And again, this is the norm in the industry. Records are released after recording agreements are signed. And it was only until FGG made a motion to dismiss that they referred to the document signed not as a recording agreement, but as AFM AFTRA documents. And indeed, they argued for dismissal of our rescission claims based on the fact that we had an alleged agreement. There was no agreement. So to put the onus on them, they always believed there was an agreement, and they believed any non-payment was a breach of that agreement. Any request made for the agreement would have been met with silence or a denial, because it turns out there isn't an agreement. Based upon that, based upon the misrepresentation that they signed an agreement and the reasonable belief that they did, we believe that Sony should be.
Stop you for, but that's the underlying fraud. That doesn't mean that you have a basis for equitable estoppel of the statute of limitations. There's got to be something else that would otherwise support an equitable estoppel argument, not the underlying fraud itself. You had an agreement. No, you didn't have an agreement. We told you you had one, but you didn't. You know, then your statute of limitations is 6 years from the fraud, or 2 years from the date of discovery, or from inquiry notice. Wait, I mean, why 55 years later? That's the question that we're grappling with. I don't understand the equitable estoppel argument. Usually that's because the person on the other side is like, don't sue, I'll make good on this. It's a separate representation on which you're relying. It's not the underlying fraud itself that can provide the basis for an equitable estoppel, right? Isn't that the law?
Well, no, an equitable estoppel requires a wrongful affirmative act upon which the plaintiffs rely in not pursuing a claim. And that wrongful affirmative act was the representation that they were signing off on a recording agreement.
And when did that occur?
1965, Your Honor.
Right, so you mean to tell me that since 1965, they didn't have to bring an action?
They have not brought an action, and as I've stated previously, I thought there was a recording agreement when I took on this case. And I was surprised when they didn't produce it, and I was surprised when FGG premised their motion to dismiss.
But nobody told your client not to sue them. That's what I'm driving at. Right. But at no point did they say, don't worry, we'll make good on this. We're going to pay you tomorrow. Don't sue us.
But that would have been a breach of contract action because they believed there was a contract.
Well, breach of contract action is more difficult for you because 6 years from the breach, they didn't pay you. In default, you had 6 years. I'm really having trouble with the statute of limitations issue.
I understand.
Okay. May I just ask, what were they saying all of that time when you said, or did anyone say, where's the contract? Did they say, oh, yeah, there's a contract, we'll get it to you? Or were they putting you off in some way?
They were non-responsive. I sent a couple of letters out to FGG and they didn't respond. And the mailings were not returned as undelivered. In terms
of 3 years before you were representing them, nobody ever asked a question about a contract?
No, Your Honor, they always believed there was a contract based upon the representation made to them and the contracts were signed before sound recordings are issued.
I think Justice Oing wants to ask a question. Mr. Mata, will you just mute yourself until we get his question so we can?
So, Mr. Mata, I just have a very quick question. I mean, your clients come to you. The parents are deceased at this point, and they're the ones who executed the contract. did you ask them if the parents ever got the contract?
Mr. Deringer's mother is still alive.
Oh, okay, great, fantastic.
And yes, I did ask her, and she did not get one.
Okay.
All right. And that's part of the concealment of this misrepresentation and this false statement made to them.
When did you first ask for the contract?
I first asked for the contract sometime in 2017. Direct to the FGG defendants at multiple addresses. And I never received a response. And when I asked,
and before 2017, between 1965 and 2017, had anybody asked them for the contract?
I am unaware that anybody asked for the contract. Having said that, they reasonably always believed there was a contract. And there really was no, I'm sorry.
Sorry. What led them to believe that? What actions on the part of the FGG, I'm sorry, led them to believe that?
It was this meeting immediately after they recorded one of the songs where they were told by Mr. Goldstein, as one of the defendants, that they had to sign a recording agreement in order for the
and they had a good attorney. They had a good attorney for them, and they signed the agreement. But from that time in 1965 on, was there anything else? Any other? Yeah, go ahead.
From 1965, there was nothing indicating to them there was no contract. Nothing. As a matter of fact, as I've said, I only learned there was no contract when it was admitted on FGG's motion to dismiss.
I understand. Okay. Do you have anything else?
If my time is up, Your Honor, I'll refer to.
You have a minute rebuttal. I'll be back to you because this is
okay.
Okay, Ken.
Your Honors, on the point of the statute of limitations and also on the issue of fraudulent concealment, I just want to note that, first of all, we don't believe that there's any fraudulent concealment on behalf of the FGG defendants. As you rightfully recognize, anytime from 1965 to 2017, any one of these plaintiffs could have hired a lawyer or even sent a letter or called and said, where's my money? Where's my money? Where's the contract? I mean, there's no reasonable basis for them to believe that there was a contract signed, allowing.
Everybody, just a minute. If everyone would mute, it seems that Justice.
Sorry. Okay. So, and counsel, it would appear that plaintiffs continued in the music business, right? I mean, entered into contracts, was dealing with other people at a way back when. I mean, it wasn't that he just became a music person, correct?
Yes, Your Honor. And I just, before my time is up, I want to note that obviously the FGG defendants, whatever you find that they did or didn't do, cannot be imputed onto the Sony defendants in terms of equitable estoppel, because there's no allegation that Sony actively did anything between 1965 and 2017. And, the entire point of the statute of limitations is to prevent claims like this, where 50 years have passed. There might have been an agreement, and we think there was an agreement. It's just that 50 years have passed, and we have not yet located a copy of the agreement. I mean, that is entirely, and people have died. I mean, I think Julie Rifkin, this key person who apparently, said all of these misrepresentations, he has since passed away. I think the FGG defendants are in their 9th decade of life. I mean, this is entirely why the statute of limitations is in place. And I just want to, especially point out that
it's not in place to keep octogenarians from being sued. They can be sued. It's in place for other reasons, but certainly a long time has passed since the underlying events that would give rise to this cause of action have taken place, and that is something that has to do with public policy and statute of limitations. If what they say is true, these plaintiffs, they have a very compelling circumstance. You have to, I'll allow for that, even if you don't.
Mr. Mota? I'm not sure that I think Mota is your name. Sorry. You're muted still.
Okay. Just to respond to Judge Oing's comment or question, that these were individuals who were well versed in the music industry at the time that they recorded the first song, and at the time that the document was presented to one of the plaintiff's parents as a recording agreement. The plaintiffs were age 17, age 15, age 19.
I agree, counsel. Yeah, I understand that. I'm just saying later on, when you could use the sort of discovery rule to kick in, they at that point, when they're in their 20s and 30s, they continued in the music business, correct? It wasn't as if they stopped after the Hang On Sloopy song came out, which I grew up with, that they stopped doing that they stopped becoming part of the music business, right? That's the only point I made in terms of, the discovery rule kicks in too for fraud, misrepresentation, and they could have done something about it.
Well, only Mr. Derringer continued in the recording and the music industry.
I think since Justice Oing can't, his a lot of background, I think he's saying they weren't 15, 17, and 19 forever. They were either became sophisticated in the music business or sophisticated, at least they were adult and no longer children, for decades, so that they would have had an opportunity to think about this and the popularity of the song and the fact that they weren't getting any royalties and follow from there. This is an unfortunate circumstance for sure, but
I've said it best. My head's bobbing.
I'm sorry.
This was Bernwick said it best. My head's bobbing. My mic might be off, but my video's not.
He agrees, is what he's saying. He agrees.
Well, the failure to pay royalties or render statements is not indicative of there not being a contract. They were told there was a contract and they believed in it. And as I've said,
No, but they knew that the song was being played. You could hear it on the radio on a 60s station now, right? So, so when they weren't getting royalties as adults, they weren't really scratching their heads before 2017, really?
If they hadn't...
That's rhetorical. I'll withdraw it.
Well, let me try to respond to it anyway.
And then we'll wrap up. Thank you. Because your time is up.
All right. Thank you.
So if you want to wrap it up?
No, that's fine. But thank you for hearing my argument. Of
course. Thank you both. Wagner versus Pegasus.
Good afternoon, Your Honors. This is David Rosenberg for Appellant Leon Wagner. Appellant is seeking a reversal of the Supreme Court's decision in order, which denied Wagner's motion for summary judgment on its breach of contract claim and its claim for a declaratory judgment that the enforcement of the set-off provisions in the 2012 promissory note was barred by the statute of limitations. Appellant is also seeking a reversal of the Supreme Court's order to the extent it granted defendant's motion for summary judgment, dismissing the complaint in its entirety. I would just like to emphasize 2 points today which support the reversal of the Supreme Court's decision. First, the Supreme Court erroneously determined that CPLR 203D, which governs when an otherwise time-barred claim may be asserted as a counterclaim or defense, is inapplicable because the statute of limitations was not implicated at all in this case. However, this is exactly the kind of case which requires the court to look at CPLR 203D to determine whether or not Pegasus can enforce its right of set-off as a defense in this action. The Supreme Court's finding that the statute of limitations was not applicable at all was based on its erroneous conclusion that the defendant, Pegasus Capital, was merely exercising a right to self-help under the promissory note.
Counsel, didn't the set-off create its, what was the purpose of the set-off if not to create its own rights and remedies against the distributions, which weren't available until 2019? What did that language mean if it wasn't speaking about a term outside of the statute of limitations. Isn't that exactly what the purpose of the set-off was?
Well, Your Honor, I think the purpose of the set-off was to enable Pegasus Capital to set off claims against an affiliate of one of its affiliates. I don't think that the purpose of the set-off was to continue in perpetuity forever its ability to enforce that right of set-off in a court of law. And I think what's determinative here is not whether or not Pegasus Capital had that right of set-off under a promissory note, but whether that right of set-off can be enforced in a court of law as a defense or a counterclaim to a pending action. And
well,
that is what
would it have been in perpetuity if it would have been, I mean, the distributions had to have come up. It wasn't something, the distributions were never going to come up. So that wasn't in perpetuity. It was once the distributions came up, then it could be used against, yeah.
No, I understand that point, Your Honor, but the timing of the distributions is really irrelevant. What they're looking to do here is enforce the right to it, that right of set-off in a pending action. So to give this argument some context, Your Honor, this promissory note was signed in May of 2012. It had a due date in December of 2012.
I'm going to stop you because we really do understand the facts of this. But when you say pending action, the reason that we have a pending action is because you brought an action for declaratory judgment. Their right of set-off was pursuant to a letter. They sent you a letter. They said, you know, gee, you know, you have a distribution coming off and we're going to keep it because we're going to set it off. So that wasn't in a pending action. They exercised it. So it wasn't, they didn't exercise it in a pending action. They didn't do that. You know, you brought a pending action, but that's sort of coincidental, I suppose. Well, I just don't get what relevance the pending action has here.
Well, I think I disagree with that conclusion. And the issue here is that the claims brought by Wagner against Pegasus Investors 5 Sustainable Luxury Limited, which I'll call Pegasus Investors 5 to save time here. That claim is based on an investment which Mr. Wagner made in 2011. And that is a claim for breach of contract, which the Pegasus defendant admittedly said they owe to Wagner as a result of the sale of the Six Senses Hotel and Spa Resorts. Without a defense or a counterclaim asserted to that cause of action, the Pegasus defendants have no defense to that cause of action.
It's true in any case, isn't it?
Pardon?
Yeah, it's true in any case. Without a defense, they have no defense. Okay.
All right. So
I'll buy that.
Thank you, Your Honor. Taking that fact to its conclusion, if Wagner had just merely asserted a breach of contract claim against Pegasus Investors 5 on its own, that claim would warrant summary judgment because there is no defense or counterclaim other than the assertion of the set-off right as an enforceable right in this action. Wagner would have...
Yeah, no, I guess you're missing my point, which is the beauty of set-off is that they don't have to put it forth in a claim. The set-off is a set-off. They just exercise the right. That's what they did here. They exercised the right. That we happen to be in litigation about it is sort of besides the point, you know.
Let me hear from, oh, sorry.
That's all right.
Are you finished?
Yes.
Let me hear from Mr. Mack. Your time is up.
You're muted, sir.
Sorry.
Sorry, I was muted. Good afternoon, Justices. May it please the court. My name is William Mack. I represent the respondents. I respectfully submit that Justice Sherwood properly granted summary judgment dismissing this action, finding that the statute of limitations were not implicated, and finding correctly that the appellant was paid in full. We respectfully request that the be affirmed. The statutes of limitations have nothing to do with...
Justice Boyne, do you have a question? Just let's everybody mute again.
I'm sorry, my mic is really bad. So I have a quick question on this. You exercise your right of set-off with respect to this agreement here, right? I mean, you just withheld the distribution. It's self-help in a sense, which the agreement allowed you to do, correct? So the interesting part then would be, I guess then the plaintiffs could could conceivably commence an action against you for breach of contract, right? But then at that point, you would have to then assert, you could then conceivably assert as a defense the set off, right? Because he's arguing you can't assert the set off because the statute of limitations and all that. But instead of a DJ action, which is interesting, they commenced a DJ action instead of a breach of contract. That's why they're trying to argue that you can't even assert the defense of set off, right? Because it's a DJ action.
Your Honor, I'm not sure I follow the question. I think the point is that statutes of limitations, and we say this in our brief, is they're defensive mechanisms. They're not intended to be used as a sword, and I think that gets to kind of the heart of what you're asking. We did what we were entitled to do under the contract, and now they start an action. Saying that we want to be paid, and you're not allowed to assert the contractual right that allowed you to do what you did in the first place, which, by the way, you bargained for and you agreed to. To continue, Justices, this CPL Article 2 has nothing to do with what happened here. 201 actually addresses the article's application, stating that an action must be commenced within the time specified in this article. It deals only with when a legal action must be commenced. We didn't sue him. We could have sued him at any point leading up to the 2019. We knew that this distribution was coming, right? So rather than go to legal expenses, rather than burden the court, rather than get embroiled
Counsel, we're aware of the facts. This has been set off, so we're stated before. So if you don't have anything further, then let's go back to your opposing counsel. Do you have anything further?
No, you're not. No.
Thank you. Mr. Rosenberg?
Yeah, so I'd just like to address 2 points. One is just to address Justice Oing's point about commencing a breach of contract action. We actually did assert a breach of contract action against Pegasus Investors 5. And in order to cut to the chase of the issue in this action, in this proceeding, we at the same time also sought a declaratory judgment saying that their exercise of the right of set-off as a defense or counterclaim to our breach of contract action was unenforceable and beyond the statute of limitations. And so I think that the procedural context here warranted that declaratory judgment action, without which I'm sure that Mr. Mack would have filed an answer asserting that right of set off as a defense or counterclaim, and we would have been in the same place. The other point I'd like to make is that this action could have been commenced by the Pegasus defendants to enforce the promissory note and collect the amounts due, but it was not. It intentionally was not done. And that is because during the course of these proceedings, going back to 2015, when the Pegasus defendants attempted to collect this money against Mr. Wagner informed them that he believed that the promissory note was not due and payable because he was defrauded into executing the promissory note, as well as investing approximately $9.5 million in the LSG transaction, in which the promissory note was effectively executed in connection with. And by permitting them to exercise this right of set-off beyond the statute of limitations, it is basically done an end run around the enforcement of the promissory note. Mr. Wagner can now no longer assert those defenses to the enforcement of the promissory note because the time under the statute of limitations to enforce that obligation has passed.
Thank you. So I'm sorry, is there a question?
I don't understand. So if your claim is that the note was a fraud, shouldn't you have just sued him fraud? I'm not really getting it.
Well,
you're claiming it was unenforceable. It was a fraud. Why didn't you sue him for fraud during the 6 year statute of limitations from the time that you signed the note?
Well, at the time,
how did we get here?
Yeah, at the time there was no action to collect on the note. We would be suing for a fraud with no damages. because there was no action to collect on the note.
Oh, it's
So
still
you thought the
debt.
fact that you had a note and you didn't, sorry, you thought that you had a note and you didn't pay anything on it, that the note was forgiven or something?
Well,
That
there
they-
was,
that set off, that said that if there was, any issue, that they could set it off. You thought that
well,
was,
we believe that there was a dispute about the enforceability of the note, and there was certainly a dispute about the investment in LSG, which is borne out in the record.
well, I guess what Judge Gish is asking is, so what happened to the 6 years? If you did believe that, didn't you have time in the 6 years to do it?
Well, we would have asserted those counterclaims or those defenses in an action to enforce the note. There was no action to enforce the note, and we believe that both the note and the enforcement of the note and the counterclaims or defenses in response to that have both expired.
One last question. Didn't you sign the offset agreement? Did you agree to the offset during the 6 years after the note, when theoretically you believed that the note was unenforceable as a fraud?
Well, they executed the offset agreement was in the note itself. So at the time they signed the note, excuse me, at the time that Wagner signed the note, he was unaware of the circumstances which, and the misrepresentations which led him to sign that note.
Okay.
Thank you.
Thank you, Your Honor.
Thank you both. Sure, thank you. People versus Odell Rhodes.
Yes, good afternoon, Your Honor. Alma
Good
Gonzalez for Mr. Rhodes. What we're requesting here is a 6-month sentence reduction, which translates to an earlier chance at release for Mr. Rhodes. There are several mitigating factors meriting that reduction, and I'll highlight just a few here. The first one being that, there is an undue hardship here on Mr. Rhodes' family, which I don't think is sufficiently accounted for. Mr. Rhodes is a father of 4. He also has his wife. All of which are now, missing Mr. Rhodes' contributions to the family, which is particularly difficult right now, given the COVID situation, given that his wife was the primary breadwinner. So she's effectively now a single parent in the middle of a pandemic, who, also has to work, but take care of her children at a time when there were also school closures. All of Mr. Rhodes' children are below the age of 12 or were at the time, and so they're still fairly young. So there's really no societal benefit to keeping him in an additional 6 months here. In addition to that, this is Mr. Rhodes' first violent felony offense. There was no threat used. This is an attempted possession of a weapon offense. There was no threat to use the firearm.
Counsel, this is Judge Owen. When you say
Yes.
attempted possession, he was arrested with possessing the firearm. No, am I mistaken? On his person.
Correct. He was.
It was a loaded 380 semi-automatic, which is not a pea shooter of a gun.
Correct, Your Honor, and we acknowledge the seriousness of that. And Mr. Rhodes took a swift responsibility for possession of that firearm. He, in fact, I believe he pleaded 2 months after the arrest, and he was fully cooperative with the officer when he was arrested for that. He was also not displaying the weapon at the time. It was actually found in his left hoodie pocket. So for that's, I think, an additional reason mitigating this down to 3 years, which is the minimum. And in addition to that, I think, the glaring unfairness that's present in this case is that when he agreed to plea to this offense, he was offered and promised 3.5 years plus 5 years of post-release supervision. And he was ultimately given 5 years of post-release supervision. So the prosecution really walked away here with 2 extra years of Mr. Rhodes' life in the sense of, obligations to the state, which he did not know he was agreeing to at the time. And in fact, he was not agreeing to.
I'm sorry, you said it was 3.5 years with how many years?
Plus 3 years of post-release supervision,
Yes, okay.
Which Mr. Rhodes is a second felony offender in this case, which is why 3 is the minimum. So the 5 years was really mandatory. The people had actually filed a predicate felony statement a month before the plea in this case. So they were well aware that they could not offer him anything other than 5 years post-release supervision. And so really in a situation here where there are no additional aggravating factors here, and where there is such undue hardship on Mr. Rhodes' family, we do request a reduction of the 6 months down to the 3, so that, you know, that still leaves with the people walking away with a year and a half more that they did not bargain for, but it at least allows Mr. Rhodes to start crediting time towards his post-release supervision.
Thank
you,
you.
Your Honor.
Ms. Bond, is it?
Yes, good afternoon. May it please the court, Rachel Bond for the people. I want to touch on first that defendant signed and executed an appeal waiver here, which bars his excessive sentence claim. He executed it in open court, said that he fully understood it.
This is Judge Gish, though. But does the fact that the court mistakenly and earnestly said you're going to get 3 years of post-release supervision as opposed to the 5 that he got, does that invalidate the waiver?
Our position is that it does not, because the sentencing court has inherent authority to correct an illegal sentence. And here, the 3 years that was promised simply could not be imposed in this situation.
I understand that. I believe that the court made the mistake in earnest, as did the prosecutor. But the question really becomes is, can it be a knowing and intelligent waiver if you made a mistake, if there was just a fact that was mistakenly conveyed? How can it be knowing and intelligent? Not whether it should have been, you know, whether it's a good sentence or not is a secondary issue, which we would consider, I suppose.
Sure, Your Honor. My answer to that would be that when it can be knowing and voluntary when the correction serves to honor the plea rather than vitiate it. For example, in People versus Johnson, which is cited by the defense, there was a legal sentence that was promised, like a sentence that could absolutely be imposed, and the court just simply decided later that it wanted to give a different sentence. Whereas here, this was the only possible term of post-release supervision that he could get. And therefore, he wasn't being promised the minimum post-release supervision. He wasn't being promised anything outside of a specific, definite term of post-release supervision. And he got the only post-release supervision he would be able to get. And just so our position is that the appeal waiver is valid. It bars his excessive sentence claim. But to move to the merits of that excessive sentence claim, for the same reasons that I argued for the appeal waiver, I believe that the sentencing court could correct the illegal sentence here. And therefore, defendant voluntarily pled guilty. He has never moved to withdraw his plea or complained about the terms when the court noted a higher post-release supervision term at sentencing than at the plea proceeding. And additionally, the sentencing court, the people, were all well aware of defendant's family situation, his prior criminal history, and the circumstances of the crime that were charged here. And I would argue that none of those things prevented him from carrying a loaded firearm in this case. As we all know, gun violence has and continues to skyrocket. It's a very serious offense to carry a gun like this out in the city. Whether or not he was brandishing it, he had it, it was loaded, it was ready to use. And so our argument is that the sentence was well deserved. 3.5 years, he got a very good bargain. He faced up to 15. And so if there are no further questions, we would just ask that the judgment be affirmed.
Are there any further questions? Okay, we're back to you, Ms. Gonzalez.
Yes, I'll just touch on the appeal waiver issue fairly quickly. So I think the Court of Appeals' case in Johnson pretty much decides this issue. You know, this was not an exercise of inherent authority to correct a sentence. In fact, it was actually a modification of the terms of the plea agreement, because at the time that the sentence was imposed, you know, at the time that the promise was made, the sentence had not been imposed yet.
But wouldn't your client then have the opportunity to withdraw the plea?
Presumably, yes, and I believe the court in this case actually offered him a chance to withdraw his plea, but that was at the start of the sentence proceedings, and it was in relation to the fact that Mr. Rhodes had not been interviewed by the probation department at that time.
But even without the court offering it, he could have done it if he thought, gee, my God, my waiver is no good. I was offered something else and I thought I was pleading to something else. Isn't that his remedy? Rather than, I mean, you talk about the court below changing the sentence, but that's exactly what you want us to do. You're not asking us to put in place the sentence that he was promised. You're asking for a whole new sentence.
Well, two things, Your Honor. The first time that the 5 years of post-release supervision was brought up was actually in the middle of the court's explanation, because Mr. Rhodes was confused, thinking that he could get a nonviolent quote sentence, and the court was confused and spent about 2 pages, I believe, of the transcript explaining that, and sort of throws in, well, you know, the promised sentence was 3.5 plus 5, and in the middle of Mr. Rhodes still trying to understand that explanation, the court slips that in and then imposes a sentence. So he didn't really have
an
much
attorney there, right?
Correct, and counsel should have said something and didn't. And you know, the prosecution also knew that this was not the offer that they had bargained for. But in addition to that, I believe Johnson is pretty dispositive in this situation. The court, you know, ended up giving a higher sentence, and also I would note did not give Mr. Rhodes a chance to withdraw consent from that appeal waiver, which is what Johnson requires. And you know, turning back to the merits and to end on that, I believe 6 months is not that much time, but it would mean a lot to Mr. Rhodes and to his family. He completely acknowledged his guilt. He's not asking for his plea back. He stands by taking responsibility for that. And for all of those reasons, Your Honor, I believe 3 years is more than enough punishment for having this weapon that he should not have had in his hoodie pocket.
Thank you.
Thank you, Your Honor.
Leck versus Leck.
Good afternoon, Your Honors. May it please the court, Stephen Storch on behalf of the appellant plaintiff, Charles Leck. The court below erred when it awarded the defendant here 1/2 of the equity of the London residence, and at the same time also held the Mr. Leck responsible for the debt that was incurred in purchasing that residence. In doing that, the court misconstrued the prenuptial agreement between the parties. That's an agreement that was heavily negotiated. Both parties had attorneys.
You know, that's true. And it seems that it almost seems that you're trying to read out of the agreement the language that entitles the wife to an ownership interest in the marital residence.
No, not at all.
Okay.
Not at all. In fact, we would submit that the trial court actually read different language into the agreement. And specifically, I think we started out with the notion of primary marital residence, and the court below found this, that primary marital residence defined in section 2.2 has to be jointly owned by the parties. There's no dispute about that. And there's no dispute that there was no residence that was jointly owned by the parties. So there was no primary marital residence within that definition.
Can I stop you for a moment? That wasn't 2.2, was in fact, though, it was subordinate to 10.2. Isn't that correct?
No.
Subordinate. It didn't say. It didn't say subject to 10.2. 2.2 is subject to 10.2. Doesn't it say that? Did I misread that?
Well, but 10.2.
Wait, not but. That's a yes or no. Does it say? Wait a minute. You don't even know where I'm going with this.
Okay, sure,
this is storage. Let's do it one step at a time, because you know what I do, and this is my style. I go to the point where we can get to what we all agree on, and then we get to the point where we really have a dispute, and then I understand your argument. But we have no argument here. that 10.2 is that 2.2 is subject to the rights and obligations in 10.2, correct? That's what it says.
I would disagree with that, Your Honor, and I'm happy to walk through the language why.
Okay, so we have a point of disagreement right at the beginning.
Right. Because if
So
you
what?
go to,
So what does? Wait, just give me one last thing.
sure.
It starts out. It says, except as expressly otherwise provided at 10.2 of this agreement. What does that mean?
It means if 10.2 is actually triggered, then I would agree that 2.2 is conditioned by 10.2. But if you go to the actual language of 10.2b, right?
Well, I didn't get there yet, but then you're agreeing with me, right? So we go to 10.2, and let's go to 10.2b, and I want you to focus in on one thing. What's a successor residence? What does that mean in that paragraph?
Well, Your Honor, I will tell you that it is not actually defined. Successor residence is not a defined term. For instance, with respect to the London residence, which was purchased before the city apartment was sold.
All right, so I'm going to accept that. It's not defined. If it's not defined, though, from the context, what could it mean? Because we have to give effect to the idea that there is a right here that concerns a successor residence. When does that kick in?
Okay, Your Honor, taking that, going to successor residence and assuming successor residence kicks in. This is one of the errors below. There are a number of factors that would go into determining whether it was a successor residence. For instance, the London residence was purchased before the New York apartment was sold. There is another residence, the Appellate residence in New York City, which was purchased after.
Well, that was only purchased after the parties separated, right?
Right. But it was purchased after. So in terms of a successor,
Then it was never a marital residence. That would, they never lived there. So we're not.
The Impala?
The Impala, isn't that where she lives with her son? They never lived there as a family unit?
It was purchased by Mr. Leck with the idea that he would move there with her and her son. But they didn't.
They never lived there like that.
Right. And successor residence, nowhere in this agreement does it say that the successor residence has to be a home where they both live. I think the issue.
But what does it have to be? I don't understand. See, this is really the problem that I have. If you're telling me the London residence isn't a successor residence, it may or may not be. That's one of the things we're going to decide. But what is a successor residence under this agreement so that I can understand what does that provision in the contract mean? What does it mean?
Well,
I know it's not defined, but what does it mean? It means something.
Well, Your Honor, it does not necessarily mean that there has to be a successor residence.
I didn't ask you what it didn't mean. I asked you what it does mean. What would be the circumstance which you believe there would be a successor residence that would qualify under this agreement? Because the agreement does talk about a successor residence. So it's got to mean something. And if you're telling me it doesn't mean the London apartment, maybe that's true or maybe that's not. So what does it mean? It's not defined. What does it mean?
I don't think there's a set of circumstances, and this is a factual issue, Your Honor, where there is a successor residence. And this agreement was
ever. Is your point that there is never a successor residence? You can't give me a hypothetical. So it doesn't mean anything in the agreement. Is that your position?
No,
if I'm trying to give you a hard time. I'm really trying to understand what the contract means.
I understand. To me, a successor residence would be a residence in New York because the prenuptial agreement provided that the parties intended to live in New York, where the parties lived together as husband and wife, and where they jointly owned. There is no such residence, which is why this provision in B, which we're talking about, goes on successor residence, or if none. It expressly contemplates that there may be a circumstance where there is no successor residence. I would argue.
And then in that case, if there's no successor residence and it relates to, if there's a rental property or something like that, it says that then he has to pay her a sum equal to one half of the value of the real property.
Well, no. What it says is one half of the real property from the sale of the residence located at 401 East 60th Street.
Yeah, but that doesn't
was sold.
exist. Mhm.
Pardon?
That doesn't exist.
Yes, it does. Those proceeds still exist. It doesn't say 401 East 60th Street has to still be owned. It says proceeds from the sale.
But do they have to be living in a rental property, though? Isn't that the condition? That they have to be in a rental property? They were never in a rental property.
That provision with respect to the rental property goes to determining whether or not you look at whether or not there's a successor. We're talking about if
Well,
none.
that's what I'm saying. But the if none is because they're in a rental property. Isn't that the fair reading of that? That you can't have a successor residence. That's the if none, because they're renting. And if they're renting, then there's a provision for her to share in the proceeds of the East 60th Street apartment.
If I may, because as I've said, and we will acknowledge this is not the most clearly written section, but if you go back now to that portion, which I think is distinct from what we've just been talking about, it says, provided if the primary marital residence is not owned by the parties or by either party, i.e. it's a rental party. If it's a rental, then you look at whether or not there's a successor. There is no dispute that the primary marital residence was not a rental. They never lived in a rental property. Once you get to that finding, then you never get to the question of whether or not there is going to be a successor residence. That's what it says. I'm sorry, I just mixed that up, Your Honor. If there's a rental property, then you look to the successor residence. I got that backwards.
So the successor residence is a rental property?
No,
it's not a rental property.
Can I explain what
I'm confused myself.
it is a confusing paragraph, but what this says, in my view, and I think it perfectly comports with the language, is if the parties had a joint marital residence, and at the time of the divorce, they had disposed of that joint marital residence and were living in a rental property. In that case, right, then the apartment in New York City or the successor to that apartment, she would be entitled to one half of the equity in those proceeds. So the condition precedent under the express language of this is that the parties had to be.
So the successor residence, as you understand it, is a successor to the East 60th Street apartment?
That's what it says. It says the apartment located at 401 East 60th Street or the successor residence there too. Now, in terms of what would be the successor to the New York City apartment, this was the apartment where the parties intended to live in New York City. It was a New York City.
Why wouldn't the apartment that they lived in after the 401 60th is the London apartment? Why wouldn't that be the successor?
Because they then purchased another property back in New York when she moved back to New York. The prenup says it contemplates.
But they never lived there. They never lived there as a family, so that wouldn't be part of this. You keep going back to the one that was purchased at the end.
But how can it's just a colloquial meaning of a successor, and successor is not defined in the agreement.
I understand.
It comes following the London apartment. All right, the London apartment came before the New York City apartment. So the only apartment that was a successor that came after the fact.
Okay, you mean because they purchased the London agreement, the London apartment 2 months after the 60th, that it's not a successor, even though that is the place that they moved after the 401 60th.
For which they did not live very long, and she left and came back to New York, saying she wanted to live in New York, which comported with the terms of the prenuptial agreement. He bought a property in New York in which she lived with their daughter. He wanted to live with her. She didn't want him to come back. In terms of what is the successor, and I think one of the things this discussion shows is that successor is not a defined term. It's a very factually intense term. And the judge decided that he was going to determine what was the successor without allowing a hearing. And here is the inequity of that. There's another provision in the agreement that says, you know, if there are multiple primary marital residences, she'd be entitled to 1/2 of the equity of the least valuable, of the lowest equity. In this case, the lowest equity property is actually the Impala in New York City. The reason she's claiming the London property as the successor residence, it has the largest equity, which is directly contrary to the expressed intent of the agreement in 2.2. To make it even more inequitable, what the judge sounded is, I'm going to give you the equity in the London residence, and at the same time, the debt you, the husband, incurred in order to purchase that residence, I'm going to stick to the letter of the agreement, and you're going to be entirely responsible for all the debt. So if this decision is allowed to stand, she ends up getting the equity in the largest share of the equity, and she's completely absolved of the debt. That's contrary to the language of this agreement. At minimum, what should happen here is it should be sent down for a trial when we get to the equitable distribution part of the trial as to what did the parties intend for successor residence? What was the situation in London? Why did she leave London and say she didn't want to come back? Why did
Okay, we've gone way over, so let's move on.
I appreciate that. Can I add one last thing?
Nope.
Oh,
Mr.
okay.
Frolic, thanks.
Okay. I was just going to say, Hang On Sloopy is my favorite song. That's all.
Well, it has been a favorite of mine over time too.
Right,
So,
for many
but-
of us.
Yeah,
Good afternoon, Your Honors. May it please the court.
I'm sorry, I said Mr. Kelly. Sorry.
It's a long afternoon. If I may, you know, at first, appellant speaks of the inequity if the trial court's decision is upheld, because then there's some sort of windfall to the respondent. And at the outset,
Yeah, don't even, because this is not a case that's really all about. Yeah, I don't think that we need to go there, honestly. It's clear, you know, he's the moneyed spouse. She makes what, 72,000 a year or something. Okay, you know,
I didn't hear the question, but I heard Justice Dish's response, which seems completely appropriate. So why don't you move on?
Yeah. So I'll ask you a quick question right off the bat, just to narrow the scope as to what could conceivably be the successor residence. Okay, the appellant counsel is arguing that the Impala residence could conceivably be the successor marital residence. My understanding of the record is that they never lived in that apartment or the Impala residence as a family, unless I'm wrong.
that's correct, Your Honor. And it was also
So right off the bat, that's out. That's off the table. That should be off the table. So now it comes down whether or not the London residence is the successor residence, correct?
Yes.
Because I understand the 2.2 says marital residence means joint ownership, no question. But then 10.2 says, well, just in case, you know, we have these other scenarios. And one of the scenarios is if they're not jointly owned or only one of them owns it. And then it says, i.e. rental residence, okay? Then you look at, then it says that the successor residence is the one that's right after the New York City apartment on East 60th Street. So in terms of how that's worded, the appellant's counsel is arguing, well, you know what? The London residence was bought before the New York City apartment at East 60th Street was sold, so that couldn't be the successor. That may be true on paper in terms of finance it, but in reality, practically speaking, it was lived in after the New York City 60th Street apartment. They lived there as a family, unless I'm also wrong with that record.
And it seems like that's the only place they've lived as a family.
That's exactly right. I agree with both Your Honors.
I got that. Thanks.
That is correct. And also, in Your Honor, you spoke to the point about the financing. The truth is that the parties, as soon as they decided to purchase this residence in London, that's when they listed the East 60th Street apartment for sale. And so the actual contract for the East 60th Street sale was in effect before the purchase of the London residence.
So your claim is, well, they didn't close on the East 60th They had in fact, they had in fact sold it and made the decision to move from there to London. And the timing it really shouldn't control here.
And
That
on
they
top of
didn't close title.
Council,
And
I have a
actually, on
question.
top- And just to piggyback on what Justice just says, you know, that all financing and everything, but if you look at 10.2, it doesn't really talk about financing, when there's the closing, when this gets triggered, when that's triggered. It's very straightforward. It's the successor to New York City residents. That's it. I mean, right? I mean,
Yes, Your Honor.
whatever happens, happens. There's no trigger points. If A, then B. If not B, then C. You know, it doesn't say on that. It's very straightforward, very simple, quite unambiguous, if you ask me. Right?
Yes, Your Honor.
Okay, got it. Thanks.
Justice Mendez, did you have a question?
Yeah, how long were they married?
They were married in 2014, and this action was commenced in the fall of 2019. So,
and for that period of time, how much time did they live together in London?
for the majority of the time, Your Honor, there until the end of 2018, when the respondent returned to the United States.
Okay.
So for the entirety of the marriage until 2018, from the start of the marriage until 2018, they resided in London. In fact, one other, I think, relevant piece of information showing that the London residence is the successor residence is that it was bought contemporaneously with the birth of their daughter. And that is the only residence that they ever lived in as an intact family.
Thank you. We're back to you, Mr. Storch. You have 1 minute.
Thank you. Just to, with respect to Justice Owen's questions, I will point out that successor is not a defined term. There are a myriad of factors that go into whether it could be the successor. The parties did not define that. The end result of this is that the court, as a matter of law, determines that it's the London residence, not the Impala residence, or as the contract provides, that there may be no successor residence, in which case there is a formula as to what she's to receive. As to what the party's intent was, the party's intent was to reside in New York. That's set forth in the prenup. It was a very short time that they lived in the London residence, in the New York residence. They went to London. The plaintiff,
Counsel, I just make one point though. 10.2 doesn't talk about parties' intent as to where they're supposed to reside.
No, but interpreting the contract, we're supposed to give, body to the party's intent.
Yeah, but only when it gets triggered or you need to look at it. I mean, the 10.2 doesn't talk anything about where they should be, where they intended to live.
No, it does talk about the primary marital residence, though, and certainly that seems to only have been the London apartment where they lived together as a family.
Not within the definition of the contract, Your Honor.
Okay, why don't we end there? We have to agree to disagree, I guess. Any further questions? Are there any further questions? If I won't.
I have it's just a question. Yeah, just for, because Mr. Storch kind of provoked it, or he brought it in my mind. There's going to be an equitable.
I was going to say a lot of questions are provoked quite often. Go ahead.
No, this may be a little besides the fact, but they have this agreement. There's going to be an equitable distribution trial? There are assets outside the agreement?
Well, there are issues. The wife, for instance, took a joint account that was jointly titled and emptied the account out of money. The wife also, during the course of the marriage, used funds and purchased herself her own apartment in Moscow. There are issues to that effect. So this
those aren't controlled by the agreement. Those are you're trying to get them back into the marital estate. Okay. I just wanted to know. All right.
Yeah.
Okay.
Thanks. Okay.
So,
Thank you both, Mr. Storch and Ms. Frawley. I appreciate it.
Thank you.
This was the last case of the day, and so court is adjourned. Thank you very much. And we can go out singing, I guess. We'd all pick the same song, wouldn't we, today? All right. Thank you, everybody.
Oh, God.